This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below.
So you might not know that I have a favorite copyright attorney as well, and it's not Leonard French. It is Richard Liebowitz, who practices in the Southern District of New York and files thousands of copyright lawsuits over very basic infringements, very, very simple basic infringements. If you copied a photo off of a Twitter account and pasted it on your website, that's enough. Now, that is enough. Under basic copyright law, that would be enough for a basic infringement. But Liebowitz seems to not only file these basic infringement claims, but then he seems to file so many of them that he can't keep up with them. And he makes various mistakes. And those mistakes, they catch up with him. Last year, he told a judge that his father had died, and that's why he was, I think, late or missed a court appearance or something. And then when the judge asked for simple details about the grandfather, it was a grandfather dying, Liebowitz continued to stall over and over and over again, eventually telling the judge that she didn't even have the authority to sanction him or question him on his grandfather's death. And eventually, he had to hire his own attorney and meet with Judge Kathy C. Bell. I went to that hearing and reported on it for you. And that's just one of a dozen of these things. He was disbarred in the Northern District of California for entering his appearance without going through the proper pro hoc vice process. Well, he's not licensed in the Northern District of California, but he can practice there if he enters his appearance pro hoc vice. And he didn't. He just filed a bunch of complaints in California without going through the pro hoc vice process first, which is what you're supposed to do. So he got disbarred there. He got disbarred from the Northern District of Illinois, I think, for not telling them about getting disbarred in Northern District of California and about other disciplinary action that he's had. And he's had a whole bunch of judges that have questioned his honesty, his methods and his honesty in various. We have a whole playlist. Just go. I'm going to put the playlist in the bubble up here. So go in and watch that. So this is Cheverest. This is Angel Cheverest versus Barstool Sports, and this is before Judge Valerie Caproni. On April 15th, 2020, this court ordered plaintiff's counsel Richard Liebowitz to show cause why he should not be sanctioned for failing to comply with the court's March 5th order. Mr. Liebowitz responded to the court's order with a declaration. Having considered his declaration, the court finds Mr. Liebowitz has failed to provide adequate reasons for his failure to comply with two simple and explicit directions. As a result, he will have to pay a civil sanction to the clerk of court of $3,000 and pay defendant's counsel in an amount equal to the fees incurred by bringing his non-compliance with this court's order to the attention of the undersigned. And 3, enroll in and complete a course on managing a small law practice. Richard Liebowitz is going to Remedial Law Practice Management School. How do you like that? This case involves claims under the Copyright Act. Angel Cheverest alleges that defendant Barstool Sports engaged in an unauthorized reproduction and public display of copyrighted photos. On March 5th, the undersigned judge issued an order referring the case to Magistrate Judge Netburn for a settlement conference. The March 5th order directed plaintiff to file proof of service no more than 3 days after service has been effected and to produce to defendants by the earlier of 14 days after service or 3 business days in advance of any mediation session, copies of records sufficient to show the royalty paid the last 3 times the picture that is at issue in this case was licensed. Now, a problem with Leibowitz's copyright cases is damages. He often sues for damages, because that's what you want in a copyright case, but he often sues for damages and hasn't provided the proof of the damages. The previous license agreements or previous license fees was something we've seen in cases before this. Here it comes up again. He's also supposed to produce the number of times the picture was licensed in the last 5 years, if it has ever been licensed at all. And plaintiffs must expressly certify whether it has been licensed as part of the production. Despite the simplicity of the order, plaintiff's counsel, Mr. Liebowitz, failed to comply with both directions. First, although service was effected March 6th, Mr. Liebowitz did not file the affidavit of service until March 31st. Second, as of April 13th, he has still not produced the required royalty information. In light of Mr. Leibowitz's failure to comply, the court ordered Mr. Liebowitz to show cause why sanctions should not be imposed. On April 30th, having been ordered by the court to submit an affidavit from the plaintiff explaining exactly what the invoice that was produced to defendant's counsel on April 14th was for, and further stating whether the picture at issue in this case has ever been licensed. If it has been licensed, the affidavit must state at least the last 3 times it was licensed and the fee. Instead, plaintiff submitted an affidavit indicating that one of the photographs at issue in this case has been licensed once. In addition, he attached an invoice that had been belatedly produced to defendant and explained that he was paid his day rate by the New York Post to take the photographs as a freelance photographer. Apparently, the New York Post received a license for all of the photographs at issue in consideration for the plaintiff's day rate. So, Federal Rule of Civil Procedure 16 allows a district court on motion or sua sponte on its own to impose sanctions on an attorney who fails to obey a scheduling or other pretrial order. The rule's explicit reference to sanctions reflects the rule's intention to encourage forceful judicial management and vests a district court with the discretion to impose whichever sanction it feels is appropriate under the circumstances. A district court's decision to impose sanctions does not require a finding that a party acted in bad faith. A district court may impose sanctions when there is clear and convincing evidence that counsel disregarded a clear and unambiguous scheduling or other pretrial order. What do you think is going to happen to the Genesis 2 church for violating a clear and unambiguous pretrial order? Moreover, in addition to any other sanction, the court must order the party, its attorney, or both to pay the reasonable expenses, including attorney's fees, incurred because of noncompliance, unless the noncompliance was substantially justified or other circumstances make an award of expenses unjust. Mr. Liebowitz, who has been described as a copyright troll, is no stranger to sanctions orders issued by the undersigned and other judges in this district. In fact, in his relatively short career, graduating in 2014 and becoming a member of the New York Bar in 2015, Mr. Liebowitz has earned the dubious distinction of being a regular target of sanctions-related motions and orders, and it is no exaggeration to say that there is a growing body of law in this district devoted to the question of whether and when to impose sanctions on Mr. Liebowitz alone. He's got his own growing body of case precedent for himself and his own behavior. This court once again joins that growing body of law and finds that a sanction is appropriate. The court's March 5th order contained 2 simple and clear instructions, both of which Mr. Liebowitz ignored. Mr. Liebowitz is familiar with both instructions. Not only are they given in every similar copyright case filed before the undersigned, but Mr. Liebowitz has previously been sanctioned by the undersigned for failing to adhere to them. I mean, you're going before the same judge making the same mistakes that you made before. How dumb is that? Moreover, Mr. Leibowitz's explanation in response to the court's show cause order is inadequate and entirely unconvincing. Failure to timely file an affidavit of service, which was filed 22 days past the court deadlines. He maintains that his noncompliance was substantially justified on account that he did not actually receive a copy of the affidavit of service from its Delaware process server until March 15th. Assuming that is true, normally the court would not be skeptical of the truth of such a representation from a licensed attorney. Mr. Liebowitz, however, has a track record of misrepresenting facts to judges in this court. See Berger v. Imagina Consulting, holding Mr. Liebowitz in contempt for lying to the court about the reason for missing a court appearance that was his grandfather's death. That one. Berger v. Imagina Consulting was his grandfather's death. Mr. Liebowitz offers no legitimate explanation as to why it then took an additional 16 days to file the affidavit of service. So he would have been fine if he had filed it on March 15th or March 16th. Mr. Leibowitz's explanation that the COVID-19 pandemic disrupted the ordinary workflow, thereby causing administrative oversights, is wholly unconvincing. The notion that Liebowitz needed over 2 weeks to get its bearings before Mr. Liebowitz was able to accomplish the simple task of filing an affidavit of service is preposterous. Although the pandemic has presumably had some effect on law firm operations, it has affected all lawyers and law firms throughout the country, it does not serve as an excuse to disregard the court's orders. Had Mr. Liebowitz requested an extension of the deadline to file an affidavit of service, the court would have considered it. Mr. Liebowitz's attempt to attribute his administrative oversight to the pandemic is disingenuous, distasteful, unpersuasive, and likely perjurious. The court notes that between March 15th and 31st, the time period during which Mr. Liebowitz was purportedly unable to file an affidavit of service, as he was getting his bearings, he filed 25 separate lawsuits in this district alone. His filing rate in 2020 is approximately 30% higher than his rate of filing cases during the same period in 2019. Moreover, this is not the first time that Mr. Liebowitz has attributed his failure to follow the court's order to file proof of service to an administrative oversight, nor is it the first time that the court has found such an excuse to be inadequate or sanction-worthy. Given the frequency with which Mr. Liebowitz commits administrative errors, the undersigned is unconvinced that they are indeed good faith oversights. As a result, the court once again rejects Mr. Liebowitz's recurring, unacceptable excuse. See also Sands v. Bauer Media Group, where they sanctioned Liebowitz and noted that a mere oversight that happens once or twice is a thing. A pattern of discovery and related abuse is quite another, and rings of deliberate indifference to an attorney's obligation to behave in a professional, responsible, and competent manner in each and every case he handles. Failure to provide licensing information. As noted above, the March 5th order directed Liebowitz to produce, within 14 days of service, the affidavit of service, and 3 days in advance of any mediation session, records sufficient to show the royalty paid the last 3 times the picture that is at issue was licensed, etc. Mr. Liebowitz has not provided that information. On April 14th, more than a month after service, Mr. Liebowitz sent defense counsel a one-page invoice from plaintiff to the New York Post, listing 4 dates and dollar amounts. He included no accompanying explanation. The invoice failed to indicate whether the pictures at issue in this case have ever been licensed. Defendant's letter informing the court that they have not received the required information also said the court should issue an order barring plaintiff from submitting any evidence of actual damages in this case with respect to both causes of action for alleged copyright information and removal of copyright management information. So in other words, since he didn't obey the court order, he should not be further allowed to correct the problem. With respect to any claim for statutory damages, a negative inference may be imposed, deeming the plaintiff to have no evidence since he didn't submit it in time, even after the court ordered him to. The court will not rule on these requests at this time. Defendant is free to bring a separate motion seeking an order if the parties are unable to settle. And on April 30th, in response to the court's subsequent order, plaintiff submitted an affidavit indicating that one of the photographs has been licensed once, in addition to the license the New York Post obtained as consideration for the photographer's freelance fee. Thus, it was only after the court directly ordered Mr. Liebowitz to submit an affidavit from his client that the invoice be explained and the license history produced. Mr. Liebowitz admits that the license fee information was not produced 14 days after service of process as per the court's order. In a lackluster attempt to justify his utter disregard for the court's order, Mr. Liebowitz simply states that non-compliance was substantially justified for all the same reasons set forth in paragraph 5 above. This explanation that the shelter-in-place order disrupted normal workflows is conclusory and unacceptable. If Mr. Liebowitz was unable to produce the documents, he should have moved to adjourn the deadline and produce the documents, rather than ignoring it altogether. He is cautioned in the Polaris case that future failure to comply with the requirement to provide the defendant with royalty information not later than the earlier of the 14 days after service or 3 business days in advance of scheduled mediation will not be tolerated. The court finds it particularly ironic that Mr. Liebowitz chastised defense counsel for violating the court's individual rules and clear mandate when it is Mr. Liebowitz who continuously fails to adhere to this court's simple instructions. Moreover, Leibowitz's statement that he somehow complied with the court's order by producing the only financial information that he has in his possession is nonsense. As noted above, Mr. Liebowitz did not produce that invoice until April 14th, almost a month past the deadline set by the order. In addition, the invoice failed to indicate whether any of the photographs had ever been licensed or to certify that none had. Thus, Mr. Liebowitz is indisputably violating the clear and ambiguous instructions of the March 5th order. Lastly, his statement, which was made in response to the court's order to show cause why he should not be sanctioned, that expressly informed him that the court concurs with the defendant that the single document produced does not comply with the court's order, that to the extent defendant does not understand the document that was produced, it is free to meet and confer in good faith with plaintiff's counsel, is close to contemptuous and definitely disrespectful. In a separate endorsement responding to plaintiff's motion to strike the invoice as containing confidential information, the court ordered, if plaintiff wishes to pursue this issue, he must explain in detail how the invoice, which merely reflects payment for unknown work on 4 days, discloses anything remotely confidential. Plaintiff's counsel failed to offer any further explanation. Moreover, the subsequent affidavit by the plaintiff revealed that only one of these dates reflected on the invoice is even relevant, and that separately, January 26, 2015, one of the photographs was licensed. None of the other photographs has been licensed. Mr. Liebowitz has entirely failed to explain why he did not notify the defendant of the actual license of the photograph. It is conceivable that Mr. Liebowitz failed to disclose the single license because it was beyond the 5-year period covered by the order. Of course, if that were his reasoning, it is not clear why he produced the invoice, which was also beyond the 5-year period. Moreover, he failed to certify as required that none of the other pictures has ever been licensed. Or why it should take multiple orders from this court to get him to produce the most basic of information regarding this case. In sum, as a result of Mr. Liebowitz's blatant disregard of this court's order, a sanction is appropriate. Notably, Mr. Liebowitz does not expressly argue that sanctions are unwarranted. He merely states that the court should exercise leniency and not penalize LLF or its counsel for this infraction, which caused no prejudice whatsoever to the defendant. The court reminds Mr. Liebowitz again that a sanction under Rule 16 does not require a showing of bad faith or prejudice. The court need only find that counsel disregarded a clear and ambiguous pretrial order. As explained above, the court has no trouble making such a finding. Mr. Liebowitz indisputably ignored both instructions in the March order. Moreover, although Mr. Liebowitz characterizes his violations as mere oversights or infractions, given the frequency of such behavior, the court highly doubts that they continue to occur in good faith. Regardless, Mr. Liebowitz's unexcused failure to follow this court's order has wasted the time of both the court and defendant. The court disagrees that the defendant has not been prejudiced. This court should have moved seamlessly from a complaint being filed, the plaintiff providing basic information to facilitating settlement, to a settlement conference and hopefully a settlement. Instead, it foundered on the first step. Because plaintiff failed to provide the required information, defendant was required to enlist the help of the court in obtaining the required information. Then the plaintiff, rather than promptly coming into compliance, filed a letter that was sneering and unprofessional and, in essence, argued that it was defendant's fault that the court was bothered as the defendant failed to alert him that he had failed to comply with the court's order. It was only at that point that Mr. Liebowitz produced to the defendant the one-page invoice with 4 freelance assignments, and only one of which was relevant, a fact he failed to disclose. When the defendant was then forced to again involve the court, Mr. Liebowitz responded not with a civil explanation of the cryptic invoice, but again with complaints about defense counsel's professionalism and a motion to strike defendant's submission on the ground that it disclosed confidential information. When the court denied the motion with direction to Mr. Liebowitz to explain how it could possibly have contained confidential information, Mr. Liebowitz responded with silence. In short, defendant was prejudiced by having to spend time and money obtaining from Mr. Liebowitz information that Liebowitz was under court order to provide. Because Rule 16 grants a court discretion to impose whichever sanction it feels is appropriate under the circumstances and to encourage forceful judicial management, a sanction of $3,000 is warranted. In Polaris, the court sanctioned Mr. Liebowitz $1,500 for his failure to adhere to the exact same instructions as are at issue here. Evidently, that was insufficient to deter Mr. Liebowitz from violating court orders. Accordingly, the prior sanction is doubled. Mr. Liebowitz is warned that a future unexcused violation of these requirements is likely to be sanctioned by an increased fine. In addition, Mr. Liebowitz must pay defendant's attorney's fees associated with this issue. As noted above, this order is neither the only time the undersigned has sanctioned Mr. Liebowitz, nor is the undersigned the only judge who has sanctioned him in this district. In Berger v. Imagina Consulting, in responding to a contempt citation that was precipitated by Mr. Liebowitz having lied to Judge Sibel, Mr. Leibowitz's attorney argued that Mr. Liebowitz should not be held in contempt and recommended a number of steps Mr. Liebowitz should take to improve the professionalism of his practice. Among counsel's recommendations was professional psychological help and a CLE course on small law firm management. While both may be helpful, psychological help is best obtained because the patient wants help. Whether Mr. Liebowitz wants to improve or not, and the court questions whether he does, this court concurs with Mr. Leibowitz's attorney and Berger that management training is in order. Wow, this is coming full circle. I went to the Imagina Consulting hearing where the judge said you should get management training. And now a different judge is saying, yeah, we're going to order you into management training. Accordingly, Mr. Liebowitz is ordered to participate in CLE training, continuing education, continuing legal education training, regarding management of a small law firm. Mr. Liebowitz must attend such training before September 1st, 2020. The course must cover the basics of setting up and running a law practice, including how to maintain systems so that court obligations are tracked and obeyed. Mr. Liebowitz is directed to provide the court with information about the course he wishes to attend for the court's approval. He will, at the end of the course, be required to present proof of attendance and to provide a sworn statement to the court on what he learned from the course and what concrete steps he has instituted in his practice to improve compliance with the federal rules of civil procedure and court orders. So he's literally being ordered by the teacher to write his statement of what he learned in his extracurricular law firm management course. That is just so satisfying that the court will do this to him. He's not being disbarred. He's not being fined $1 million. He's not being sent to jail. He's being told you're doing a bad job. Learn to do a better job. And here's a slap on the wrist that's getting increasingly harder and bigger and more slaps on the wrist. So he is set to pay a civil sanction of $3,000 for his failure to comply with the order. He's going to pay the opposing side's attorney's fees, and he is going to attend a approved law firm management course. Not later than May 11th, defendant shall provide Mr. Liebowitz with his billing rate and the number of hours spent in connection with this issue. So literally the judge only gave the defendant the weekend to figure that out. Within 15 days, Mr. Liebowitz must pay the total civil sanction to the clerk of court of $3,000. File proof of payment of the civil sanction. So 15 days to pay the civil sanction, or I guess he'll have to request formally an extension. He must provide the court with information about his management course, the law firm management course, not later than June 1st. And that is Valerie E. Caproni, United States District Judge for the Southern District of New York. So, yeah, that was, shall I say, entertaining. And I hope that are you not entertained? I hope that you are all entertained. Also, I hope you've learned something about lawyers. We're actually supposed to do our jobs. We're not supposed to be scammers or commit this kind of shenaniganery that Liebowitz is engaged in. There's no problem with him being a copyright troll in the sense that he files a lot of copyright plaintiffs' lawsuits. We can disagree with that on a policy level, on a personal level, on a piracy level, but we shouldn't disagree with it on the ethical level. It is ethical for plaintiffs to pursue their case. It's unethical for plaintiffs and their lawyers not to follow court orders, not to follow the rules, not to own the copyrights in the case of Prenda Law, which has nothing to do with Liebowitz. Those attorneys went to jail anyway. Liebowitz isn't going to jail, at least not for this. Liebowitz is just getting fined. And as long as he pays the fine or responds and does what the court says to the court's satisfaction, he's not going to jail. And go ahead.
We do have some questions.
Go ahead.
In the chat, basically asking why he's still a lawyer at this point. And I was wondering if you could comment on the process of discipline.
He's very close. Every one of these things is getting him closer and closer and closer to not being a lawyer. Lawyers are lawyers because they have the right to be lawyers based on their training, their learning, their testing, and their character. So Liebowitz seems to have fine learning and training and everything. He seems to have terrible character, but it doesn't seem to be the most dishonest character. It seems to be like a kid who gets caught with his hand in the freshly baked birthday cake that mom was making and then says, no, it wasn't me. Like, you can see there's cake all over the kid's face. You can see a kid-sized handprint in the freshly baked cake, but the kid still maintains his innocence. And the judge is like mom, trying to say like, okay, I understand he's a kid. Like, I understand he's a lawyer. He's a plaintiff's lawyer. He's a bit of a shyster lawyer. He's a bit of a shenan. He's a bit of a like shady lawyer. But he's not as bad as other lawyers who have, like I said, with Prenda Law, who forged client signatures, who didn't own the copyrights, who ceded to BitTorrent the files they wanted to sue over, who constructed out of nothing the claims that they wanted to make against people, and then made those claims and recovered millions of dollars from those people. So those people went to jail and those people got fined. And so somewhere in between is Liebowitz. Somewhere in between wholly innocent and jail is Liebowitz. So the judges are really trying to figure out what to do with him. He's not the worst, but he's certainly not doing his job. So they're trying to figure out like what sanctions are best for him. But yeah, a suspension or disbarment is definitely coming up for him. Now, Judge Caproni and Judge Siebel, back from the Berger v. Imagina Consulting case, they don't have the power to disbar Liebowitz. All they have the power to do is recommend to the disciplinary committee that he be disciplined. The disciplinary committee has to figure out whether he's disciplined and what discipline is appropriate. So maybe that's coming. Disciplinary committees often take years to get through their disciplinary actions. Maybe there is currently a disciplinary action winding its way through the New York. It's not the Supreme Court, because the New York Supreme Court is the lowest court in the land. Maybe it's winding its way through the New York. I forget what the highest court of New York is called, but maybe it's winding its way through that court system. Other questions?
I think it was just, that
like how in the world? Yeah, so it's frustrating. I'd like to see something more happen to lawyers who are this bad. At the same time, it's reassuring that a simple mistake isn't going to cost me my law license or cost me sanctions. A simple mistake should be correctable as long as you eat crow while the crow is young and tender, or else surely, Mr. Liebowitz, you will eat it while it is old and tough. You don't want to eat it while it's old and tough. You don't want to eat crow at all. So eat it while it's young and tender before it gets crow and tough, before it gets old and tough.
I guess in my mind, I'm wondering at what point the judges are going to start really increasing the amount of sanctions per case, because obviously the previous levels of sanctions were not doing the deterrent effect. Yeah.
And Ewan says, can't the federal court disbar him from the federal court? Yes, the chief judge, probably after a review by the disciplinary committee of the district court, could probably disbar him from that one district court. They are acutely aware that he is a New York attorney and that disbarring him from the New York court will likely mean he doesn't work anymore. So I don't think they want to disbar him, taking away his job, until that is the absolute last thing that can be done. But it's getting there. He's definitely creeping along the path to being disbarred in one way or the other, or at least suspended. I would think he'd be getting a 6-month suspension for this level of misbehavior. I would expect that to come down at some point. Remember, the lawyer for the Proud Boys not remember, because I haven't announced this yet. The lawyer for the Proud Boys lied about his firearms being stolen in a false police report. He got 6 months suspension. So here, Liebowitz is borderline lying to the judge, kind of a lie by omission, more of a lie of just, being too vague, a lie of vagary, I guess. That's not the same thing. It should be at some point, but not yet. I think maybe we could disagree. Maybe it's reached that point now. But just the first time it happened, maybe it was just like a lie of omission, a lie of vagary. Not so bad as lying about your firearms being stolen and making that in an official police report. But we're definitely getting real close to some sort of significant action being taken by the court. And people continue to hire him. Apparently, he filed 25 cases in a month. People continue to hire him. I'm not sure what's going on there, but people continue to hire him. Okay. The world is unfair and unjust, is all I have to say about that. Let me know what you think in the comments below. So that is our show, everyone. Thank you for joining me. I'm Leonard French, your favorite copyright attorney, and this is our legal education and legal news channel, Lawful Masses. Support us on patreon.com/ljfrench and sponsors.com/law if you are able. It really helps our channel out and makes it possible to make these videos at all in the first place. Thank you very much to our $50 plus supporters in the month of May. I love how long this list is. Joe Tyson, Wes Delj, Nicely Done Defense, Video Remonetized, John Steele, Gavin Barnard, Eevi, Kyle Mudrak, Spirit Bear, Negrey, Michael Pearce, Daniel Perez, Blackleaf, Benjamin Hitov, Stephen, Ottah, Cute Grills in Your Area, Longreach Jones, Zachary Chaney, Mullen PC, Ugly Grill, Shielo T, Josh Baker, Gregory, and Rudolph Bescherer Jr. And the $5 plus supporters are scrolling on the LED matrix panel next to me. I am Leonard French, your favorite copyright attorney. I will see you in the videos that drop. I love you all. Stay safe, stay healthy. We're going to get out of this whole thing together safely. Bye.